Hello students, welcome to the lecture on business laws. After this lecture, we will be able to learn the following objectives. Define the nature, meaning and significance of law. Explain the sources of Indian law. Describe the sources of English law. Define the mercantile law in India. Now let us know more about basics of law. According to the Oxford English Dictionary, the word law means rule made by authority for the proper regulation of a community or society or for correct conduct in life. In the words of Woodrow Wilson, law is that portion of the established habit and thought of mankind which has gained distinct and formal recognition in the shape of uniform rules backed by the authority and power of the government. Broadly speaking, the term law denotes rules and principles either enforced by an authority or self-imposed by the members of a society to control and regulate people's behavior with a view to securing justice, peaceful living, and social security. There are several branches of law, such as international law, constitutional law, criminal law, civil law, mercantile or business law, etc. Nature, meaning and significance of law. Let us see this video to understand the topic, meaning of law. The nature and meaning of law has been described by various jurists. However, there is no unanimity of opinion regarding the true nature and meaning of law. Therefore, it is not practicable to give a precise and definite meaning to law which may hold good for all times to come. However, it is desirable to refer to some of the definitions given by different jurists so as to clarify and amplify the term law. Hereinafter, we shall refer to some representative definitions and discuss them. For the purpose of clarity and better understanding of the nature and meaning of law, we may classify the various definitions into 5 broad classes: idealistic, positivistic, historical, sociological, realistic. Idealistic definition of law. Under this class fall most of the ancient definitions given by Roman and other ancient jurists. Alpine defined law as the art or science of what is equitable and good. Cicero said that law is the highest reason implanted in nature, whereas Justinian's Digest defines law as the standard of what is just and unjust. In all these definitions propounded by Romans, justice is the main and guiding element of law. Ancient Hindu view was that law is the command of God and not of any political sovereign. Everybody, including the ruler, is bound to obey it. It may be noted that there are 2 main factors of the definition. First, that to understand law, one should know its purpose. Second, in order to ascertain the true nature of law, one should go to the courts and not to the legislature. Positivistic definition of law. According to Austin, law is the aggregate of rules set by man as politically superior or sovereign to men as political subject. In other words, law is the command of the sovereign. It obliges a certain course of conduct or imposes a duty and is backed by a sanction. Thus, the command, duty, and sanction are the three elements of law. Kelsen gave a pure theory of law. According to him, law is a normative science. The legal norms are ought norms as distinct from is norms of physical and natural sciences. Law does not attempt to describe what actually occurs, but only prescribes certain rules. All norms derive their power from the ultimate norm called Grund norm. Historical definition of law. Saving's theory of law can be summarized as follows: that law is a matter of unconscious and organic growth. Therefore, law is found and not made. Law is not universal in its nature. Like language, it varies with people and age. Custom not only precedes legislation, but it is superior to it. Law should always conform to the popular consciousness. Legislation is the last stage of lawmaking, and therefore the lawyer or the jurist is more important than the legislator. Sociological definition of law. Duguid defines law as essentially and exclusively as social fact. Eyhering defines law as the form of the guarantee of the conditions of life of society assured by state's power of constraint. There are three essentials of this definition. First, in this definition, law is treated as only one means of social control. Second, law is to serve social purpose. Third, it is coercive in character. Roscoe Pound analyzed the term law in the 20th century background as predominantly an instrument of social engineering in which conflicting pulls of political philosophy, economic interests, and ethical values constantly struggle for recognition against background of history, tradition, and legal technique. Realist definition of law. Realists define law in terms of judicial process. According to Holmes, law is a statement of the circumstances in which public force will be brought to bear upon through courts. According to Cardozo, a principle or rule of conduct so established as to justify a prediction with reasonable certainty that it will be enforced by the courts if its authority is challenged is a principle or rule of law. To summarize, following are the main characteristics of law, and a definition to become universal, one must incorporate all these elements. Law presupposes a state. The state makes or authorizes to make or recognizes or sanctions rules which are called law. For the rules to be effective, there are sanctions behind them. These rules, called laws, are made to serve some purpose. The purpose may be a social purpose, or it may be simply to serve some personal ends of a despot. Separate rules and principles are known as laws. Such laws may be mandatory, prohibitive, or permissive. A mandatory law calls for affirmative act, as in the case of law requiring the payment of taxes. A prohibitive law requires negative conduct, as in the case of law prohibiting the carrying of concealed weapons or running a lottery. A permissive law is one which neither requires nor forbids action, but allows certain conduct on the part of an individual if he desires to act. Laws are made effective by requiring damages to be paid for an injury due to disobedience, by requiring one, in some instances, to complete an obligation he has failed to perform, by preventing disobedience, by administering some form of punishment. Let us watch another video to understand the significance of law. What is rule of law?
When everybody is free to say what they want. Justice?
The rule of law is holding people accountable to the law.
The law must emanate from the people. Look, the law lives in the consciousness of the people. If you don't have that, you don't have law.
In countries where the rule of law is absent, ordinary people do not have access to the justice system. Imagine you're walking down the street and you're suddenly approached by plainclothes police officers from a secret security agency. You're taken to a prison, you're tortured, you're abused, you're held without any legal grounds, and you have just simply disappeared.
The rule of law emanates from the people of a nation. Yet there are countries where the rule of law is not a common practice.
Without the rule of law, you have a nation where its citizens' fundamental rights and well-being are not protected.
The United States Institute of Peace believes that rule of law is the lifeblood of a society.
One example of how we bring in voices of the people into the process is through justice and security dialogue, where we bring citizens, government, police, and others together to build trust, identify the rule of law challenges, and come up together with joint solutions and strategies.
The rule of law is more than about one person, or even groups of people. The rule of law is a process, but once constructed can be enduring.
What we're seeing in the world is people's demand for a voice in decisions that affect their lives. For a society that provides justice, security, and accountability for everyone. In other words, a society that abides by the rule of law.
Significance and relevance to modern civilized society. Law is not static. As circumstances and conditions in a society change, laws are also changed to fit the requirements of the society. Modern science and technology have unfolded vast prospects and have aroused new and big ambitions in men. Materialism and individualism are prevailing at all spheres of life. Law has undergone a vast transformation, conceptual and structural. The idea of abstract justice has been replaced by social justice. Sources of Indian law. The general meaning of the word source is origin. The sociologists find law in numerous heterogeneous factors. For theologians, law originates from God, Vedas, and the Quran, which are the primary sources of Hindu and Muhammadan law, respectively, are considered to have been revealed by God. The modern Indian law, as administered in courts, is derived from various sources, and these sources fall under the following two heads. Principal sources of Indian law, secondary sources of Indian law, principal sources of Indian law. The principal sources of Indian law are customs or customary law, judicial decisions or precedents, statuses or legislation, personal law, example Hindu and Mohammedan law, etc. Customs or customary law. Custom is the most ancient of all the sources of law and has held the most important place in the past, though its importance is now diminishing with the growth of legislation and precedent. A study of the ancient law shows that in primitive society, the lives of the people were regulated by customs which developed spontaneously according to circumstances. Customs have played an important role in molding the ancient Hindu law. Most of the law given in Smritis and the commentaries had its origin in customs. Custom as a source of law has a very inferior place in the Mohammedan law. Classification of customs. The customs may be divided into two classes. Customs without sanction. They are those customs which are non-obligatory and are observed due to the pressure of public opinion. These are called as positive morality. Customs having sanction. They are those customs which are enforced by the state. It is with these customs that we are concerned here. These may be divided into two classes, legal and conventional. Customs. These customs operate as a binding rule of law. They have been recognized and enforced by the courts, and therefore they have become a part of the law of land. Legal customs are again of two kinds. Local customs. Local custom is the custom which prevails in some definite locality and constitutes a source of law for that place only. But there are certain sects or communities which take their customs with them wherever they go. They are also local customs. Thus, Local customs may be divided into two classes: geographical local customs, personal local customs. These customs are law only for a particular locality, sect, or community. General customs. A general custom is that which prevails throughout the country and constitutes one of the sources of law of the land. The common law in England is equated with the general customs of the realm. Conventional customs. These are also known as usages. These customs are binding due to an agreement between the parties and not due to any legal authority independently possessed by them. Before a court treats the conventional custom as incorporated in a contract, following conditions must be satisfied. It must be shown that the convention is clearly established and it is fully known to the contracting parties. There is no fixed period for which a convention must have been observed before it is recognized as binding. Convention cannot alter the general law of the land. It must be reasonable. Like legal customs, conventional customs may also be classified as general or local. Local conventional customs are limited either to a particular place or market or to a particular trade or transaction. Requisitions of a valid custom. A custom will be valid at law and will have a binding force only if it fulfills the following essential conditions, namely, immemorial antiquity. A custom to be valid must be proved to be immemorial. It must be ancient. According to Blackstone, a custom, in order that it may be legal and binding, must have been used so long that the memory of man runs not to the contrary, so that if anyone can show the beginning of it, it is no good custom. English law places a limit to legal memory to reach back to the year of accession of Richard I in 1189 as enough to constitute the antiquity of a custom. In India, the English law regarding legal memory is not applied. All that is required to be proved is that the alleged custom is ancient. Certainty. The custom must be certain and definite and must not be vague and ambiguous. Reasonableness. A custom must be reasonable. It must be useful and convenient to the society. A custom is unreasonable if it is opposed to the principles of justice, equity, and good conscience. Compulsory observance. A custom to be valid must have been continuously observed without any interruption from times immemorial, and it must have been regarded by those affected by it as an obligatory or binding rule of conduct. Conformity with law and public morality. A custom must not be opposed to morality or public policy, nor must it conflict with statute laws. If a custom is expressly forbidden by legislation and abrogated by a statute, it is inapplicable. Unanimity of opinion. The custom must be general or universal. If practice is left to individual choice, it cannot be termed as custom. Peaceable enjoyment. The custom must have been enjoyed peaceably without any dispute in a law court or otherwise. Consistency. There must be consistency among the customs. Custom must not come into conflict with the other established customs. Judicial precedents. In general use, the term precedent means some set pattern guiding the future conduct. In the judicial field, it means the guidance or authority of past decisions of the courts for future cases. Only such decisions which lay down some new rule or principle are called judicial precedents. Judicial precedents are an important source of law. They have enjoyed high authority at all times and in all countries. This is particularly so in the case of England and other countries which have been influenced by English jurisprudence. The reason why a precedent is recognized is that a judicial decision is presumed to be correct. The practice of following precedents creates confidence in the minds of the litigants. General principles of doctrine of precedents. The first rule is that each court lower in the hierarchy is absolutely bound by the decisions of the courts above it. The second rule is that in general, higher courts are bound by their own decisions. This is a special feature of the English law. High courts. The decisions of high court are binding on all the subordinate courts and tribunals within its jurisdiction. The decisions of one high court have only a persuasive value in a court which is within the jurisdiction of another high court. In a high court, a single judge constitutes the smallest bench. A bench of 2 judges is known as division bench. 3 or more judges constitute a full bench. One bench of the same high court cannot take a view contrary to the decision already given by another coordinate bench of that high court. The high courts are the courts of coordinate jurisdiction. Therefore, the decisions of one high court are not binding on the other high courts and have persuasive value only. The Supreme Court is the highest court and its decisions are binding on all courts and other judicial tribunals of the country. Article 141 of the Constitution makes it clear that the law declared by the Supreme Court shall be binding on all courts within the territory of India. Supreme Court. The expression all courts used in Article 141 refers only to courts other than the Supreme Court. Thus, the Supreme Court is not bound by its own decisions. However, in practice, the Supreme Court has observed that the earlier decisions of the court cannot be departed from unless there are extraordinary or special reasons to do so. If the earlier decision is found erroneous and is thus detrimental to the general welfare of the public, the Supreme Court will not hesitate in departing from it. The Supreme Court is not bound by the decisions of Privy Council or Federal Court, statutes or legislation. Legislation is that source of law which consists in the declaration or promulgation of legal rules by an authority duly empowered by the Constitution in that behalf. It is something called jus scriptum, written law, as contrasted with the customary law or jus non scriptum, unwritten law. Supreme legislation is that which proceeds from the sovereign power in the state or which derives its power directly from the Constitution. It cannot be repealed, annulled or controlled by any other legislative authority. Personal law. In many cases, the courts are required to apply the personal law of the parties where the point at issue is not covered by any statutory law or custom. In the case of Hindus, for instance, their personal law is to be found in the Shruti, which includes 4 Vedas, the Smritis, which are recollections handed down by the rishis or ancient teachings and precepts of God, the commentaries written by various ancient authors on these Smritis. The personal law of Mohammedans is to be found in the Holy Quran, the actions, precepts and sayings of the Prophet Muhammad, which though not written during his lifetime, were preserved by tradition and handed down by authorized persons. These are known as hadiths, ijmas, that is, a concurrence of opinion of the companions of the Prophet and his disciples. Qiyas, or reasoning by analogy, these are analogical deductions derived from a comparison of the Quran, hadiths and ijmas when none of these apply to a particular case. Digests and commentaries on Mohammedan law, the most important and famous of them being the Hidayah, which was composed in the 12th century. Secondary source of Indian law. Justice, equity and good conscience. The concept of justice, equity and good conscience was introduced by Impey's regulations of 1781. In the absence of any rule of a statutory law or custom or personal law, the Indian courts apply to the decision of a case what is known as justice, equity and good conscience, which may mean the rules of English law in so far as they are applicable to Indian society and circumstances. In its modern version, justice, equity and good conscience as a source of law owes its origin to the beginning of the British administration of justice in India. High courts established by the British government directed that when the law was silent on a matter, they should decide the cases in accordance with justice, equity and good conscience. Sources of English law. The chief sources of English law are common law. The common law in this context is the name given to those principles of law evolved by judges in making decisions on cases that are brought before them. Thus, common law denotes that body of legal rules, the primary sources of which were the general immemorial customs, judicial decisions, and textbooks on jurisprudence. Law merchant. The law merchant is the most important source of the mercantile law. Law merchant means those customs and usages which are binding on traders in their dealings with each other. In all other cases, a custom has to be proved by the party claiming it. Principle of equity. The equity courts had their separate existence from the common law courts in England until the passing of the Judicial Act of 1873, when the separate existence of such courts was abolished and all high courts were empowered to grant either or both the remedies, common law as well as equity, according to the circumstances of each case. Statute law. Statute law is that portion of law which is derived from the legislation or enactment of Parliament or the subordinate and delegated legislative bodies. It is now a very important source of mercantile law. A written or statute law overrides unwritten law, that is, both common law and equity mercantile or commercial law. Mercantile law is related to the commercial activities of the people of the society. It is that branch of law which is applicable to or concerned with trade and commerce in connection with various mercantile or business transactions. Mercantile law is a wide term and embraces all legal principles concerning business transactions. The mercantile law or law mercant or lex mercatorla is the name given to that part of law which grew up from the customs and usages of merchants or traders in England, which eventually became a part of common law of England. Sources of mercantile law. The following are the main sources of mercantile law: the law merchant statute law, common law, principles of equity. These have already been discussed under the headings Sources of English law. Mercantile law in India. The main sources of Indian mercantile law are English mercantile law. The Indian mercantile law is mainly an adaptation of English mercantile law. However, certain modifications wherever necessary have been incorporated in it to provide for local customs and usages of trade and to suit Indian conditions. Acts enacted by Indian legislature or statute law. The following acts enacted by the Indian legislature from time to time are important for the study of Indian mercantile law. The Indian Contract Act 1872, the Sale of Goods Act 1930, the Indian Partnership Act 1932, the Negotiable Instruments Act 1881, Judicial Decisions. Judges interpret and explain the statutes. Whenever the law is silent on a point, the judge has to decide the case according to the principles of justice, equity, and good conscience. It would be accepted in most systems of law that cases which are identical in their facts should also be identical in their decisions. Customs and trade usages. Most of the Indian law has been codified, but even then, it is not altogether done away with customs and usages. Many Indian statutes make specific provisions to the effect that the rules of law laid down in a particular act are subject to any special custom or usages of trade. Now, in the end, let us summarize what we have learnt in this lecture. Summary: law is not universal in its nature. Like languages, it varies with people and age. A prohibitive law requires negative conduct, as in the case of law prohibiting the carrying of concealed weapon or running a lottery. Mercantile law is related to the commercial activities of the people of the society. Equity is a body of rules, the primary source of which was neither custom nor written law, but the imperative dictates of conscience, and which had been set forth and developed in the courts of chancery. Custom is the most ancient of all the sources of law and has held the most important place in the past, though its importance is now diminishing with the growth of legislation and precedent.